Yes, Article 5.4, Article 5.4.
My Lords, I've dealt with the case that the High Court actually addressed as the respondent sees it, balance of probability versus real risk as a standard of proof. Before I leave that, though, and move on to Article 5.4, can I say something about the halfway solution that's offered by the respondent? That's to say that there is no fixed standard of proof, and it should vary from case to case. And can I say simply this, and invite the court to focus on the implications of the respondent being right about that, either because, as he says, there is no burden of proof in Strasbourg, therefore no standard of proof at all, or, as he argues, illegitimately borrowing wording from Othman, that the burden and the only burden in any given case is what the judge thinks is fair to impose. Can I invite the court just to contemplate for a moment the consequences of that being right? It would result in a legal framework, especially for extradition courts, that is completely untrammeled and unprincipled and ungoverned by any real rules at all. In an extradition case, a convicted defendant would be able to roll up to court with an Article 6 complaint, or indeed any complaint of any article under the Convention, and his first submission would be that there should be a low standard of proof applied to his or her complaint. For example, because they're going to have a tough job of getting evidence to substantiate their allegations. In every case, court would be beset by submissions, rulings, appeals, case law on the standard of proof as it applied to any given factual situation, and that, we respectfully submit, just can't be right or tolerated. The truth is, there is a standard of proof. Strasbourg sets it at beyond reasonable doubt, UK law at balance of probabilities, and the court was wrong to suggest otherwise. So with that said, can I turn then to the respondent's new alternative suggestion, which appears to be that even if the standard of proof for the issues that the High Court addressed was indeed balance of probabilities and he can't meet it, the absence of future remedy in Romania, he says, could form a standalone basis to refuse surrender because there would be no judge reviewing the legality of his detention under Article 5, Subarticle 4. Our first answer to that submission is that it wasn't argued below. The respondent was well aware of Romania's then position on future remedies. Page 369, we've been to it. And none of what he submits now was submitted below, or at least not clearly enough to occur to the courts below that this was some separate legal point. None of the case law that he now relies on under Article 5.4, Todorov, Etude, were cited or produced below. There's no hint in the High Court's judgment that it was argued in that way. It doesn't feature in the judgment at all. It's not part of the certified question before this court. And the court, of course, doesn't travel lightly beyond the certified question. So if, despite all of that, the respondent is permitted now to mount a fresh legal argument, our position is that fairness ought to permit Romania now to clarify its evidence on future remedy. Here, procedural fairness is reversed. It would be unfair to shut out Romania from what is now said to be a determinative issue of fact. And Romania's evidence, we submit, shows that Romanian law does afford multiple mechanisms to access a future court to review the legality of detention. In the end, and this is why I dealt with the issue in the way that I did at the beginning of our submissions, whatever arguments there are between the Romanian prosecutor and the respondent's expert, they do agree that Romanian law allows the national courts to directly apply the provisions of the Convention. Can I just refer, my lords, to the evidence on this, just so you have it? I understand entirely that if there were a material dispute between the parties, the court would not be equipped to get involved in it, but that's we respectfully submit, not the case. So the Romanian prosecutor's evidence, whatever else is said about other avenues of redress, you will find at Supplemental Volume 2, page 18. It begins in the second paragraph. It's a direct plea to Article 6. The practice, third line, practice of the courts permit to challenge.
Sorry, you're going to have to help me.
No, it's my fault. I'm sorry. So supplemental.
I've got page 18.
Does it begin from our perspective?
Yes.
Second paragraph. The prosecutor then turns to Article 6 itself, analysing the jurisprudence of the Constitutional Court, High Court and other courts in Romania. We underline that there are objective, decisive elements to show that the practice of the courts permit to challenge the national court decisions and judgments, citing directly the jurisprudence, the provisions and jurisprudence of the European Court of Human Rights. This happens by extending and interpreting the provisions of the criminal code in new circumstances that were not covered by the legal provisions that are indicative of a violation of human rights, for example, Article 6. High Court applies this procedure and examples are given. And then you can go over to page 19 for the conclusion. From this perspective, we consider that even if Mr. Popoviciu would decide not to use the cases stipulated by the national law in respect of extraordinary appeal proceedings, he has the possibility of challenging the decision alleging directly the convention. So that's Romania's position. That whatever the shortcomings or otherwise of the national legal conventional provisions for challenging upon surrender the legality of his detention, he would be able to go to a Romanian court to make a direct plea to a breach of Article 6.
Which court?
Any national court.
Well, I mean, this paragraph that you found on page 18
yes.
Seems to support the idea that if you are before the court, you can advance the argument. Is there any agreement as to how the person, if sent back to Romania, would get before the court to advance these arguments?
There is some further information on this issue because the respondent's expert responds to that. And you will find that at page 30 of the same bundle. And my Lord Stevens, the answer is the High Court. See second paragraph, or middle paragraph on page 18. Dr. Chirita, Professor Chirita, begins his treatment of this issue at paragraph 20, and he confirms that the Constitution does allow for the national courts to directly apply the provisions of the Convention when national legislation is contrary to the provisions of the Convention. Article 20 provides that if there are contradictions, it is the international regulations which take precedence.
I do beg your pardon. Could you just give me the relevant page again?
30 of Supplemental Volume 2.
Thank you. Rio.
So there is a power. It may be little used. It may be difficult to predict, see paragraph 21 of Dr. Chirita, but everybody now agrees that there is a course of action available to the respondent in Romania to challenge the legality of his detention. And that analysis finishes at paragraph 30 on page 33. It is, in theory, a possible course of action. Although Dr. Chirita can't say whether it's going to avail or not.
I was wondering how that works out. If he started his proceedings today in the High Court in Romania, and he alleged that the trial judge was corrupt, would the state say, oh, I can't possibly answer that question at the moment because of all sub judice?
In this country?
No, in Romania. If you say he's got recourse to the Romanian courts, he can go to the Romanian courts and say there's been a breach of Article 6, a past breach of Article 6, on the basis of corruption on the part of the judge. How does that play out in practice in Romania? Do the Romanian authorities say nothing? Do they say, well, we can't possibly answer that question because we're presently investigating whether or not the judge was or wasn't corrupt, and we don't want to interfere with his fair trial rights?
Well, there's no evidence at all that that would be the response of the Romanian court. The evidence is that this is a procedure that would seize the Romanian courts of the problem, and how it resolved that problem.
Yes.
Is, in our respectful submission, neither here nor there, so long as it did resolve it and didn't abrogate its responsibility to review the legality of the respondent's detention. There is no evidence that that could or would eventuate.
Okay.
This course of action which Dr. Chirita is referring to is said to be, in theory, a possible course of action, but cannot be considered to be an effective remedy.
Well, that's his view, because he's never seen cases play out in respect of it. But the prosecutor assures this court that it is a prospective remedy available to address this issue that has arisen in this case if it requires addressing upon surrender for the purposes of Article 5.4.
But this much is not common ground. That is not common ground.
Yes, it is. It is a remedy that is available as a matter of law under Article 20 of the Constitution.
I see. So the disagreement as to whether in practice it might afford any practical
That's
remedy.
that's
right.
the
That's as far as it
extent of
goes.
the disagreement now. But, and I said at the beginning of my submissions that we don't need to enter into any of this, and can I explain why? The reason we don't need to grapple with this novel argument about the existence or otherwise of a prospective court determination of the legality of detention in Romania is because the review that he seeks lies in these proceedings themselves. The High Court here has assessed the alleged Article 6 breach and found it to be, on what we say the right standard of proof is, unproven. Or using the Strasbourg language, unproven beyond reasonable doubt. The burden the respondent would face in any Article 5.4 review proceedings would be to show that his detention was unlawful. And a court with power to discharge him has examined that very issue and found no breach of Article 6. A court, a competent court, has found, on what we say the right standard of proof is that the detention is lawful. There is no principle of convention law whatsoever which holds that the court which undertakes the Article 5.4 review must be based in the home state or even based within the territory of the convention. And can I just finally make that proposition good? My Lords, Perez is an early decision of the Strasbourg Court. Which involved, amongst other things, let's go to it, page 4665 is the decision. It was a sentence transfer case, much the same as Drodst, which we've already looked briefly at. Defendant convicted in Andorra. Andorra, then not a party to the convention. Transferred to serve his sentence in France, whereupon he complained that no French court would examine the legality of his detention by reference to the shortcomings of the Andorran judgment. The court's response to that is at paragraph 31 on page 4686. 4686, my lord. Having examined the law which says that if there are new circumstances, you're entitled to access a court to determine the legality of your detention by reference to them, the court's view was the fact that Mr. Perez was detained in France now is not a circumstance of that kind. The Tribunal de Court, that's the Andorran court, was the competent court. The review required by Article 5.4 was incorporated in its judgment. So it doesn't matter whether the reviewing court is within the state you are now in or somewhere else. It doesn't even matter whether the reviewing court is within the convention space. As long as a court has determined the legality of your detention by reference to the qualitative requirements of Article 6, Article 5.4 is satisfied. It need not have power to quash a conviction, it just needs to have power to prevent your continued detention, and that's precisely what the UK extradition courts have power to do. With power to order his discharge, the UK court has examined his complaints and, we say, based on the right standard of proof, should have found them unproven. See paragraph 162. It simply isn't sufficient to suggest that there may be grounds to believe for a real risk that will be suffered in Article 6 violation, and that would satisfy a review under Article 5.4. That's not the case. The burden on you under Article 5.4 is to show that your detention was unlawful. Compare Article 5.3, which is the initial burden on the state to justify your detention. So, my lords, our answer to the new issue is, firstly, it shouldn't be permitted to be raised at this stage. But secondly, if it is, we should be permitted to adduce evidence as to the existence of domestic remedies in the future. And thirdly, and in any event, the remedy that the respondent complains is not going to have is one that he has had. A court has examined what he wants to say about judicial corruption.
I was just wondering how that argument sits coherently with the argument you made earlier on, or the submission you made earlier on, that in order for that Articles 5 and 6 go hand in hand, that Article 6 you have to establish in a conviction case a past breach. Article 5 you have to establish a real risk. And as I followed your argument, it was that there would be no real risk if there was a possibility of review in the requesting state. And
Yes.
and here it seems to be somewhat different insofar as you're saying that there's no need for a review in the requesting state because the matter's been determined in this state.
That's because the question that we are answering has been inverted. In the first issue, the respondent's burden is to show that he is at risk of being detained. In the second, his argument is that there is no court that will entertain that argument at all. The answers to those questions disclose, we respectfully submit, two sides of the same coin. There's no illogicality.
I also thought it was common case that the Strasbourg court would entertain it.
Yes.
Yeah. So
I don't think I need to suggest that the Strasbourg court itself would constitute the Article 5.4 resolution. That's never occurred to me, but I can't imagine that that's how Article 5.4 works. It requires national courts to review the legality. It requires somebody to have access to a national court to review the legality of detention. And the respondent has. My lords, unless I can assist.
Well, could I just ask you about the second of your third submissions in relation to Article 5.4? You say you should be allowed to address it with new evidence. Is the new evidence that you wish the court to consider confined to the passages to which you have referred, or are you asking that this court remit the matter, if we were with Mr. Fitzgerald, to the High Court to determine the wider dispute between the parties as to Romanian law?
Under Article 5.4.
Under Article 5.4.
Our position, my lord, is that which is common ground between the parties is sufficient for the court to determine this issue, and that's the basis upon which I have presented this aspect of our argument. If you're against me on that, and you don't regard that which is common ground as sufficient to establish the prospective remedy that is complained about, then yes, I would invite you to remit for the remainder of the disputed evidence between the prosecutor on the one hand and Professor Chirita on the other hand, whether Article 453 1A or 1D is available in law and in practice. Yes, we would invite you to remit that question, but we say you don't need to.
Yes,
because of that which is.
I'm clear what your initial point is, which is that what you say is the undisputed position is enough. But I just wish to quiz you on whether you had a fallback, and the answer is you do.
Thank you, my lords. Unless there's anything further I can assist with, those are our submissions.
Thank you very much.
My lords, if it would assist you, can I just touch on that final point first, while it's fresh in the minds of the court? Firstly, we do deal with this in our notice of objection to the new evidence in the supplementary bundle 1 at pages 23 onwards. And your lordships will see there that set out there as a starting point where they said neither the prosecutor nor the hearing prosecutor was aware at the time of the investigation of the case of the existence of a friendly relationship. And the National Anti-Corruption Directorate didn't have information about a possible hiding by the judge of such a relationship.
Sorry, where are you reading?
It's page 23 of the supplementary bundle.
Which paragraph?
It's set out at paragraph 1, my lord. Does my lord have the quote, point B?
Yes, thank you.
Does your lordship have that? Yep. So you see that there it says, even if it proves the existence of a friendly relationship between the mentioned persons at this procedural moment, such aspect would not constitute a reason to review a final decision according to Romanian legislation in force. My learned friend says that was not a point taken in the court below, but as we set out, it was accepted at paragraph 3 that there would be no remedy. It was accepted by both parties. At no stage was it suggested the DNA letter was inaccurate or unclear. It was accepted as meaning what it said. And, my lord, if you look, can I just take you to the bundle at page 635? You'll see that in submissions, so page 635 at paragraph 8 and 9, you'll see that in submissions before the High Court, we did take the point, paragraph 8. So despite substantial and compelling evidence that the judge's impartiality was vitiated by a prior and undisclosed relationship with Mr. Bakali, the situation is as follows. Firstly, the prosecution have done nothing to dispel the doubts that the evidence gives rise to, that if the appellant is removed from a contracting state, he should be exposed to a real risk of being subjected to a flagrant denial of justice. And yet Hoffman establishes that where such evidence is adduced, it is for the government to dispel any doubts about it. Secondly, there is no remedy since the Romanian authorities have stated that the prior relationship between Judge Tudoran and Bakali would not constitute a reason to review a final decision. This situation, that's the second Roman 2, of itself gives rise to substantial grounds for believing that there is a real risk of a flagrant denial of justice. The flagrant denial of justice arises from a system that cannot even address or put right such an obvious injustice. So whether it's under Article 6, there should be access to the courts to put it right, or Article 5.4, we were taking that point.
Yes, but you didn't argue expressly an Article 5.4 point, did you?
Well, my lord, it's under the heading...
I can read what's said there.
No. Well, my lord...
Let's face the fact. Did you ever put to the High Court that you had a claim under Article 5.4 based on the absence of a supervising court?
My lord, no, not in those terms, but it just simply that the absence of a remedy itself gave rise to a flagrant.
Gave rise to the real risk of a flagrant.
No, my lord, yes. But then it was developed. It was one of the issues at issue D in the statement of facts and issues. That the question you'll see at page 24. In any event, where the High Court concludes that there are substantial grounds in violation, where there is no prospective remedy, is extradition compatible with Articles 5 or 6? And then that was stated. And then, my lords, you'll see that we've developed the point there. The issue was then raised, as you can see from paragraph 7 onwards, for the first time when the new evidence was served in April, I think it was, or 21st of March. And then the reliability of the proposed new evidence we deal with at paragraphs 11 onwards. My lords, can I just then indicate, since my learned friend has dealt with it, there's the new evidence of Langkranjan, and my learned friend now seems to be majoring not on 4531A, which he was relying on but can't be relied on because it requires new evidence showing that the conviction was unfounded on its merits. Not on 4531D, because that would require a criminal conviction of perverting the course of justice, but instead he is now relying on the European Court. And can I just show my lords what we say about that in Supplemental Bundle 2 at pages 22 to 23, if it would assist. Having, as it were, shot duds in relation to Article 4531A and D, they now resort to the European Court. And as you see, there is then Prosecutor Langkrangen's answer in relation to earlier claim in her report of 27th March that as a last resort mechanism, the Criminal Procedure Code provides for a retrial in the case where the European Court of Human Rights decided there had been a violation of one of the rights of the Convention. That assertion, at least, was clear. So, as it were, you can apply to the European Court. Now, however, she appears to be suggesting that there could be a direct reliance on the requirements of the European Convention in the domestic courts, and that, as my learned friends indicated, that's what he is arguing. So, just look at what the history of it is. Firstly, in the letter of the 2nd of February, this is at the top of page 23, they alleged there was no remedy at all. Secondly, in their letter of the 27th of March 2023, they claimed that there would be a remedy if there was a favourable finding by the European Court. And then last, and we say somewhat desperately, in their report of 8th of May 2023, they claimed for the first time that there may be some mechanism to directly invoke the European Convention in the domestic courts. And Professor Karitsa makes clear that whilst it is in theory possible to seek such direct application, this cannot be considered in any way to be an effective remedy, because there's no procedure laid down, and the remedy of appealing directly to the European Convention as affording a separate avenue would not be effective in practice. And my Lord, I know I don't need to remind the Court of the countless European Court cases saying a remedy must be practical and effective. You can't just say there's a theoretical possibility, which we just fought up, having ruled out any remedy at all, firstly, then said only a remedy if you win in the European Court. Now, well, perhaps you could go to the court. This really, in our respectful submission, is 3 significant changes with a last one, which is what my learned friend is majoring on. And if you read what Professor Karitsa says very fairly and carefully, at pages 30 to 31, he's effectively saying that there is no such remedy. It's never been tried or proved, and the exception was one where there'd been a ruling as to unconstitutionality before. So, my Lord, I do respectfully submit that the point remains one which I would invite your Lordships to consider. If your Lordships do come to the view that this is the final.
But, Mr. Fitzgerald, how can we consider this point? We have one side saying the Romanian law is this,
yes.
You have another side saying the Romanian law is not this. How, without testing expert evidence, can a court decide the matter, and particularly a court of final appeal? Well, we are not in the habit of hearing evidence.
My Lord, can I keep the reply to that until the very end? But, my Lord, I simply make the point that this further remedy has been sprung on us at a very late stage.
Yes, well, and for that you're not to blame. This course of supplementary bundles was initiated by the prosecutor.
My Lord, yes.
Yes.
My Lord, then if we go back to the main issues, if I can, and take you through it as per the case. And, my Lord, first of all, the question of what the court actually decided may be important rather than dealing with the words of various tests. But just if I can take the court to paragraph 162 at page 198. What the High Court found was that there was credible evidence of a number of allegations. And the court can see, I have nonetheless come to the conclusion that Dojana, Dumitrescu and Opris provide credible evidence of at least the following allegations against Judge Tudoran. He had long-standing relationship with Purvu, in the course of which he had improperly and corruptly assisted Purvu in legal matters. He also had a relationship over a number of years with Purview's friend Bacali, in the course of which he had again provided improper and corrupt assistance. He had participated in illegal gambling sessions for both those men, and he'd received one bribe and solicited another. I cannot conclude on the balance of probabilities that his allegations are true, that's to say, having heard the evidence, but in all the circumstances of this very unusual case, I accept they may well be. So the finding is the allegation of corruption and bias may well be true. And the question is, what is the value of that when one's assessing whether there has been a flagrant denial of justice in the past? And my lord, what Hoffman says is, it all depends, when you come to a flagrant denial of justice, on what test can fairly be imposed. That's the test. What test can fairly be imposed? And it's not a free-roving thing. Flagrant denials of justice are as rare as the blue moon. There's about 3 cases. Hoffman is one. This is another. There was a case, AD and SS, where the SIAC found that because Colonel Gaddafi would be ordering the judge to convict, there'd be a risk of a flagrant denial of justice. All the cases where there's been a flagrant denial of justice have either been because of torture, see Hoffman, or because of a profound question as to the independence and impartiality of the judges. So they're very extreme cases. And all the cases which emphasize the highness of the test of flagrancy emphasize the magnitude of the injustice if someone is exposed to it. Somebody sent back to Gaddafi's Libya to be convicted by a judge who's obeying orders from Colonel Gaddafi. The Hoffman case. This case. If your allegations are credible, and if credible, they satisfy the extremely high test of those very rare cases where there's a flagrant denial of justice, and they're uncontradicted, in my respectful submission, that satisfies the burden of proof that can fairly be imposed, and that's the test in Hoffman. And my lords, if we look at paragraph 163 after that, they then deal with the fact that he actually had a meeting, I think it was in September, October of 2012, so just before the trial started in January 2013. And the particular point has been taken away from by the John's change of it at the date, but in fact it was perhaps more significant that it was only a few months before the hearing. But the more general point remains that there is said to have been at least recent contact between the complainant and the trial judge, which was never disclosed to the appellant. The respondent, 163, has plainly failed to put forward any evidence or information which dispels these concerns. Now, the approach, have you raised a case that gives rise to the demand for an answer? Answer yes. Has there been an answer? Answer no. Therefore, you've satisfied the burden of proof that can fairly be imposed on you. Is, in our respectful submission, sufficient on the facts of this very special case? And, contrary to my learned friend's suggestion about, this will open the floodgates, you always have to satisfy the very high test that the allegations which must be credible and uncontradicted are allegations which would meet the very high test of a flagrant denial of justice. And, my lords, if we look at that, there are 2 special factors there. There is, firstly, the magnitude of what's at stake, a complete annulment of the right to a fair trial. That's the test for a flagrant denial. It's got to be that there is really no fair trial, which would be the case if the judge was corrupt and effectively knew the key witness and the complainant in the case and had these relationships with him. And secondly, so it's the magnitude of the case, and secondly, are there special difficulties of proving it? And the answer is yes, in this case. And my lords, so we say that the High Court were right at least to find that it may well be true. We respectfully submit they should have gone further. They were right to find that there had been nothing done to dispel the concerns, which could lead to the conclusion that therefore it was proven on the balance of probabilities. And thirdly, they were entitled therefore to draw an inference. Now, my learned friend then says, well, don't draw any inferences from their silence. And he says, look at page 368. So if we look at page 368, we have the answer. My lords, neither the case prosecutor nor the hearing prosecutor was aware at the time of the investigation of the case, etc., of the relationship and another person involved in the trial. So why do they put at the time of the investigation of the case to qualify it? If
that
not, because
that might at least suggest there was no collusion.
Yes, but they don't say, and it's simply not true. Also, the National Anti-Corruption did not have information about a possible hiding by the judge of such a relationship. And then, even if it proves the existence of a friendly relationship, at this procedural moment, such aspect would not constitute a reason to review a final decision. And then, my learned friend says that you can get from the following statement that they are denying it. What they say is, a certain Dojana was investigated in the criminal case of Section for Combating Crimes, a case which was connected. They don't say, and that was thrown out in 2016, which was the evidence, unchallenged evidence of Dojana. At page 5681, he said the case was thrown out. He didn't know about it at the time, but he was told that it had been thrown out in 2016. So that's completely misleading to suggest, my learned friend was saying, he's someone facing a criminal charge. He had been, there was an in rem investigation in 2013, never led to an in personam investigation, and was booted out in 2016.
Well, Mr. Fitzgerald, the last three sections of that paragraph disclose, I think, that the state prosecutor, so that it was decided in June 2016 to decline the competence to settle the case in favour of the prosecutor's office.
Yes.
So it looks as if that the anti-corruption body passed the file to the prosecutor's office.
Well, my lord, nothing further. His unchallenged evidence, and I've given you the reference, was that was the end of it in 2016. And my lord...
Yes, but you were accusing the Romanian authorities of a lack of candour.
Yes.
But they do refer to an incident in 2016.
To decline the competence, yes. Well,
so the prosecutors, the anti-corruption directorate didn't pursue it. Yeah. And passed the file to the prosecutor's office. Well, so was there anything to be cross-examined in Mr. Giordano's evidence when he said that the NAD, NDA, didn't pursue the matter?
Well, he said he was told that it had been closed. Yes. That the file had been closed. That's what he said, and he wasn't challenged, but it's still open.
Well, I do think we have to read the Romanian letter as a whole.
Well, my lord, can I just pass on to a second point in relation to that? We have then the statement from my learned friend that if you look at the second allegation, which is dealt with at 1603, at page 372, my lord, by ordinance of 15th of 2nd, the criminal investigation in rem regarding the commission of abuse was initiated, and the ordinance ordered the extension of the criminal investigation regarding the commission of the crimes. And then they say at the bottom, can be observed the criminal investigation in rem started in this case on the 15th of May 2019. And then they say that there's a reference to Judge Bogdan proposing the hearing of several witnesses, and it hasn't resulted in anything. But, my Lord, there are two things here. Firstly, here, raised in this case was an issue of profound corruption, and the two people involved were Tudoran and Bekali. The question was specifically posed and asked, did they know each other? The prosecution must have some duty to ask them, well, do you know each other? Not incriminating to say yes or no. And if their answer was, I'm not going to answer that question because it's incriminating, the court might draw its own inferences. But the complaint made by the court is this is the finding of the High Court, there is no basis on which I could reject the response of the respondent to a formal request for information about the relationship between Judge Tudoran and Bekali. So, and we had posed, my Lord, I can show it to you, we'd posed repeatedly the question, do they know each other? No answer. Bekali is their chief prosecution witness. Why can't they ask him? And so, my Lord, I do respectfully submit that an inference can be drawn. Moreover, 1603 contained allegations, not just an allegation made by Mr. Dojano, who my learned friend says should be regarded as suspect, but also from Dobrin, Liviu Dobrin, who made allegations of corruption and association, Catalin Dumitrescu, who made a Section 9 statement, so they could have insisted on him being called, who made the same allegations, Unguriano, who made allegations that there was Judge Tudoran was always associating with the Autovit, he was omnipresent at the Autovit offices with Pervert Floria, and there's no reply. So we do respectfully submit this is a case where the finding that it may well be true and the absence of any negativing of that justifies saying they have discharged the burden that can fairly be imposed upon them.
Discharged which burden?
Well, that's exactly. I'm taking you to my Lord. It's Hoffman. My Lord. I'm just quoting the words of Hoffman itself. It's clearly a burden which is less than balance of probabilities, because that was the issue in Hoffman. Could I just take my Lord? Would you just, if I bear with me, if I just take you to that point in Hoffman, because that's where these words come from, and you see in Hoffman. The question is posed at page 2608, my Lord, of the bundle. However, even accepting that there is still only a risk that the evidence against the applicant was obtained by torture, for the following reasons the court considers it would be unfair to impose any higher burden of proof on him. So it's a question of what burden of proof is it fair to impose on him. Firstly, the court does not consider the balance of probabilities test as applied by the majority of the House of Lords in A is appropriate in this context. This case concerned proceedings in SIAC, etc. These proceedings were very different from criminal proceedings, whereas in the present case, a defendant might face a very long sentence of imprisonment if convicted. Exactly analogous with this case. And I recall Sir Nicholas Bratzer saying in the European Court, but these are criminal proceedings. You can't apply tests for civil proceedings. You don't say if the juror is saying, I was influenced or tampered with, the burden is on the balance of probabilities. You say the verdict is unsafe if it may well be true. And we've got cases that show that. These are criminal proceedings in which, as they say, secondly, they look at the case law and they make the point that there's a case of the Düsseldorf Court of Appeal, at the bottom of 275, where they find it was sufficient there's a real risk that Turkey would not respect Article 5. Reasonable evidence statements made but had been obtained by torture. Again, it's enough that there's reasonable evidence. And here we say there's reasonable evidence of profound corruption by this judge and an association with Becali. Thirdly, and most importantly, due regard must be had to the special difficulties in proving allegations of torture. Now, what could be more difficult than proving a clandestine and corrupt relationship between a judge and a witness? The same special difficulties apply. People don't go round advertising that they're corrupt or that they're biased, just as torturers don't go round advertising the fact that they're torturers. And so, my Lord, we respectfully submit that third thing, the special difficulties, applies also. And then, if we go on, of course, my learned friend says, well, that's because of the special preeminence of torture. We do respectfully submit that, and we've cited in the case, numerous cases, LM, Findlay v. UK, Al-Hassan, where the courts have said the most fundamental principle is that the court must be impartial. Well, so if the court isn't impartial, or may well not be impartial, how is that universal norm complied with? And, my lords, if we then go to paragraph 280, therefore the court considers that given the absence of clear evidence of a proper and effective examination of Abu Horshaw and Al-Hamshah's allegations, by the applicant had discharged the burden that could be fairly imposed on him. So, my lord, in answer to your lordship's question, they clearly were saying it is not necessary to prove it on the balance of probabilities. 40% would do. I mean, my lord, we know that there's a range between more than negligible, more than fanciful, less than total, which is substantial.
I've always thought that a real risk was something that was more than fanciful.
Yes,
that has substance, and that could be anything.
Yes, my lord, I agree that. But in this case, what the judge says, there's credible grounds for believing on a series of allegations, and then there's silence.
From my own perspective, I'd like to know the answer to Lord Hodges' question. What is the standard?
Well, my lord, I accept. But if you look at the cases where it succeeded, it's clearly in Abu Qatada, the Othman case. It was that there was credible and substantial evidence, serious grounds for believing. In this case, they may well be true. It's clearly something more than 10%, 15%. It's up on 30s and 40s. May well be true. And, my lord, of course, as your lordship put to my learned friend, that's before you've factored in, and then there's the silence. Because they make that finding at 362, and then they go on to say, despite these concerns, they haven't been dispelled. So, my lord, I would respectfully submit that the test is, if there is, I would put it, if there are strong grounds for suspecting, substantial grounds for suspecting that there has been bias and corruption, and it's unrebutted, then the respondent has discharged the burden that can fairly be imposed on him.
I didn't think the answer to my question about the burden was difficult, because my understanding was you were arguing that on the particular facts of this case,
yes,
the Court of Appeal got it right at paragraph 167.
Yes, my lord, yes.
So really, Well, what you're saying is if there's substantial grounds for believing that there was a real risk of a serious Article 6 violation,
Yeah.
that got you home.
Yes, my lord, but when one says substantial grounds for believing a real risk, my learned friend has the point that there's, as it were, double things: substantial grounds and real risk. What it in fact meant was they found that it might well be true. They found that there was
Yes.
I mean that really was what they were saying.
Yes, there's a lot of verbiage tied in, but basically they're saying we can't decide this on balance of probability, but on the evidence we've heard, we think there's a real risk that this trial was a flagrant injustice.
Yeah, I'm sorry to be, but I quite like the expression "may well be true" because it gives a bit more substance to real risk rather than it just being 10% or something like that. But my lord, that's what they come to conclude at the end. My lord, I accept that. So, my lord, that's really the position. And then if I could just take you, we do have some core submissions which I think really don't say much more than I've already said, but perhaps it's helpful to have it in writing. And it's in the supplementary bundle,
Yes.
the much page, so it's supplementary bundle 3, page 14. So just so your lordships will see that it is there, as a matter of European convention law, there's no inflexible rule that there is a burden on the conviction case to prove on the balance of probabilities. The conviction was vitiated by bias on the part of the trial judge in order to make out the real risk of flagrant arbitrary detention. That's in the future. The question is one of whether the requested person has discharged the burden that can fairly be imposed upon him. And that's, you've seen it at paragraph 273 and 280 in Hoffman. That reflects the test in Hoffman, but it also reflects the general rule in the European courts that the burden of proof is not borne by one party or the other. I accept my learned friend's point that that's about the burden of proof. And the court can draw inferences from the conduct of the respondent government in proceedings before it. And we've given you the references to Merabishvili. Perhaps I should just take your lordships back to it. It's at tab 20 at page 2478. But it is significant because one sees there, my learned friend put the hypothetical, well, what would happen if he went to the European court? And the answer is they would apply the Merabishvili approach. And that does say when you've raised an issue, it must be dealt with satisfactorily. And so, my lords, if you see 311 at page 2477, no strict application of the principle affirmanti incumbit probatio, and then at para 3112, although it relies on the evidence which the parties adduce, the court routinely on its own motion asks applicants or respondent to provide material which can corroborate or refute the allegations. If the respondent government in question do not heed such a request, the court cannot force them to comply with it, but can, if they do not duly account for their failure or refusal, draw inferences. And we say this is such a case, and in fact there's a finding of the court that their response was unsatisfactory and they didn't conduct proper investigation. And then they deal with the question about proof it can follow from strong, clear and concordant inferences. Well, applying that test in this present case and doing away with national tests beyond reasonable doubt, there are a number of factors here, all of which the court refers to and all of which they're entitled to take into account. And we've set them out at paragraph 7, page 17. Firstly, there was the evidence of Dojana, Opris and Dumitrescu.
Page 17 of...
Page 17 of the supplementary bundle.
Bundle 3.
Sorry, Mark.
We're reading the notes separately.
Yes, I'm so sorry, Mark. If you go to page 17 of supplementary bundle, does my lord have that?
Yes.
Yes, so paragraph 7.
Yes.
The number of factors which justify the High Court's finding there was a real risk of flagrant by reason of his conviction by Judge Tudoran. Firstly, there's the evidence of Dojana, Opris and Dumitrescu as to the corrupt relationship between the judge and the key prosecution witness, Bacali, which the court found might well be true. Secondly, the objective fact that he was a suspect and the subject of an in personam investigation for unexplained wealth and influence peddling, that this was likely to have prompted his premature retirement, and he'd been evasive in seeking to avoid interview. So there's all that, my lords, which the court recites in its judgment at 27 to 32. If you're looking at strong concordant evidence, look at what he does. The moment the in personam comes, he says, I'm not going to... he retires prematurely, forfeiting his pension rights. And that's, I think, at paragraph 27 on page... Yes, paragraph 30, at page 170, asked to resign, a step which would result in his forfeiting certain pension rights to which he would have been entitled if his retirement had taken place as planned. His resignation is accepted, and I'll call him Judge Tudoran. On the same day, Prosecutor Moraru began a criminal investigation in personam for offence of making false declarations. In October 2019, Moraru wished to interview Judge Tudoran, but was unable to do so because Judge Tudoran was in a psychiatric hospital. This all leads to a strong suspicion, and it suggests that he was being evasive in avoiding interview. Then there's the silence of the IGA, and I've dealt, my lord, with that. At the very least, the court made a finding that it was very unsatisfactory that they conducted no investigation. They didn't just not respond to Jojana, they didn't respond to Oprist, Dumitrescu, and the others. And, my lord, I'll take to those. And then there's the lack of a remedy. My lord, if you, just to give you some idea of how strong that evidence was, can I just in advance take you to the summary, the evidence of Dumitrescu. He did, contrary to what the court thought, he did put in a witness statement, and your lordships can see at page 121 of the case, 2.25, obtained a Section 9 statement.
This is back into the main bundle, is it?
Yes, into the case, my lord. Yes. So sorry, my lord. Yes. Back to the main bundle, page 121. The response. Paragraph 2.25 at the top of the page, your lordships will see, obtained a Section 9 statement from Dumitrescu. Following the notarized statement, his statement gave a detailed account of his first-hand knowledge of witnessing Tudoran attend gambling sessions with Floria Purvu. He stated, on the basis of what I saw myself, I declare and confirm that since at least 2002, when I came to be employed, I observed and noticed that Floria Purvu, Judge Tudoran, met regularly, talked, ate together and gambled, and they're very good friends. Now, that was put in a Section 9 form. It was open to the prosecution to say, we're not going to accept it unless you call him. Then we have, there was after that, you have the statement of Oprist, which again, one might think they would have disclosed because we were asking questions about the relationship between Tudoran and Bakali. But if you look at page 123, we there summarised Oprist's complaint. Of course, he wasn't making his complaint in order to assist Mr. Popoviciu. He was making a completely freestanding complaint himself, which was he made in February, but was February 2020, but was only came to our notice in March 2021, just before the hearing. And your lordships see that. It's particularly powerful evidence, given that it was not made with a view to assisting the respondent proceedings, and involved details of Judge Tudoran's criminality in covering up crimes. My lords, I'm not going to read it all out, but I do invite the court to look at it. I mean, these are not trivial crimes. He's covering up for effectively an offence of manslaughter. And Dr. Oprist described his knowledge of the very close relationship between Judge Tudoran and Floria Purvu, detailing the ways in which the judge provoked assistance to Purvu in his business dealings and personal affairs. He provided a specific example of Judge Tudor helping Purvey to cover up the criminal case involving the death of his girlfriend, Alice. So that's at page 389. And then going over, he stated that he'd heard from Judge Tudor's son that Judge Tudor had expected to benefit financially. You've got that at the bottom of page 385, my lords. And then 2.39, Opera stated that Judge Tudor and Bacali met together regularly, that Judge Tudor assisted Bacali with his purchase of Stoya Sports Club, and that Judge Tudor had offered to solve Bacali's pre-trial detention issue in return for a bribe. And that's, my lords, at pages 392 to 393. Opera said that Judge Tudor himself told me these things, and that he was bragging about it to display his power and influence. So, my lord, what we do say is there's a formidable body of evidence. It doesn't stop there, because there's Dobrin, who we have summarised at page 2.45, and he actually did provide a Section 9 statement too. And confirming his earlier statement.
I beg your pardon. Which page are you on now?
Page 127, my lord.
Thank you.
Does my lord have it 2.45?
Thank you.
And it refers back to his earlier notarized statement. And there was also a statement, in fact, from somebody called Ungurianu, which is referred to at page 118 at 2.14. That wasn't in Section 9 form, but it was a notarized statement. And, my lord, the strict rules of evidence do not apply, and notarized statements are admissible. CB in Westminster Magistrates, which your lordships will see footnoted at. I'm so sorry. It's footnoted in the bundle at it's at page 119 at the bottom of 119. That the strict rules of evidence don't apply. So there was a formidable body of cross-corroborating evidence before the court, and then there was no reply to it other than what you've seen, and which only dealt with a suspicion in relation to Dojana and not in relation to the others that the court relied on, Opris and Dumitrescu. And we say that the silence against that background is highly telling, and that there is authority that can elevate a prima facie case or strong suspicion into actual proof. That comes from both the European court and from the courts of the English courts. So, my lords, if I could just briefly go back to that summary.
Are you going to take us to those cases?
To the case.
The cases.
Sure, my lord.
Cases that vouch that
yes, absolutely, my lord.
a strong case followed by silence.
Yes.
Can elevate a case of strong suspicion into proof.
Absolutely, my lord. It's in the supplementary note. It's Preston Petrodel Resources, tab 49, at paragraph 44, page 3582. And so, my lord, one can look there, page 3582. Paragraph 44 of the decision of Lord Sumption. At the bottom, the courts have tended to recoil from some of the fiercer parts of this statement about inferences. For my part, I would adopt, with a modification which I shall come to, the more balanced view expressed by Lord Lowry in the ex parte Coombs case. In our legal system generally, the silence of one party in the face of the other party's evidence may convert the evidence into proof in relation to matters which are or are likely to be within the knowledge of the silent party, and about which that party could be expected to give evidence. Thus, depending on the circumstances, a prima facie case may become a strong or even an overwhelming case. But if the silent party's failure to give evidence can be credibly explained, even if not entirely justified, the effect of his silence in favour of the other party may be either reduced or nullified. Well, my lord,
what is your position here? Are you saying that the Romanian prosecutor knew about these things and stayed silent? Or are you saying that the Romanian prosecutor failed to investigate in the face of this evidence?
yes, well, my lord, certainly the second of those, but certainly the second of those, and that was the finding of the High Court. But what they were saying is we would have expected an answer. And
yeah, but these authorities, I think, and this passage
yes.
from Lord Lowry
yes.
is talking about the silence of a party about which he could be expected to give evidence. The implication being that he was in a position to give evidence on that matter.
Yes. My lord, that it's really a combination of the duty of candour to disclose matters which may fundamentally undermine the case, and with the duty to investigate and inquire. After all, just consider the position. I hope it's not unfair under English law. In a Court of Appeal case, it comes out for the first time that the judge knew a particular criminal who was the chief prosecution witness. And the allegation is made, the prosecution would investigate it. And if for some reason they couldn't get to the bottom of it, they would simply drop the case. They would say, we can't fairly deal with this. Because once there's been a finding that this is prima facie credible and calls for an explanation or an answer, the absence of an answer is highly relevant. Becali's their witness. They've been able to get him to come to the court. Your Lordship, Your Lordship saw all the evidence about the retractions. So first of all, he says, I won't give evidence. Then he comes and says, I've got nothing to say to incriminate Mr. Popoviciu. Then he's threatened with prosecution. Then he comes and says, I will say something. Highly suspect witness in that respect, with a criminal conviction. And the prosecution, who've been perfectly able to threaten him with prosecution if he won't come to court, could easily have said, you've got to answer this question. Did you know Judge Tudoran or not? Likewise, with Judge Tudoran, if you don't answer this question, we will have to abandon the case. You've got to tell us. The question was asked. Do they know each other? And there's no evidence that either Judge Tudoran or Mr. Gigi Becali were asked. And the court says they've done nothing to dispel the concerns. So, my lord, I would respectfully submit that in those but, my lord, that may also indicate that with an allegation of this sort, going to flagrant denial of justice, the burden and standard of proof can only be may well have been. So, my lord, can I just put it in these two alternative ways? Either the may well have been found at 362 is enough because of the kind of problems that we've identified about, or the judge might say, well, I'm not going to answer that because I might incriminate myself, or because I'm under investigation. So all you can do is say, it may well be true, because of the nature of the allegation and the nature of the problems. Or, and this is our alternative route, that silence converts the prima facie evidence, which is referred to at 362, into proof on a balance of probabilities.
Yes, well, that's what I thought your case was.
Well,
that you were upholding the Court of Appeal's test, but in any event, you're criticising delicately the Court of Appeal for not giving more weight to the failure
Yes.
of the state to respond to those concerns, which, when taken with what the Court of Appeal found, would give rise to a proper finding on balance of probability.
Yes, my lord, I'm very grateful. If your lordship see, we've set it out in the case.
Yes.
The way we put it, we say.
That was my understanding of what you were saying.
Yes. So, firstly, we say, and this is at 1.12, the High Court was correct not to require the respondent to demonstrate on the balance of probabilities that the trial judge was partial and corrupt. It's correct to rule that it sufficed in the circumstance of this case there was credible evidence that the judge may well have been partial and corrupt. And, my lord, at paragraph 154, they make the point in the judgment, why should the test be different for past and future in this particular context? And, my lord, we do respectfully make the submission that the magnitude of what's at stake is the same in both cases. What's the risk you're trying to obviate? The risk when you apply the future test of real risk is the risk of someone suffering a flagrant denial of justice, which is a very extreme and exceptionally bad, as it were, violation of the right to a fair trial. The real risk is the test there. When it's the past, and the allegation is of flagrant denial of justice, the magnitude of what is at stake is just the same. The risk that someone is going to be detained on the basis of a flagrantly unfair trial before a corrupt and biased judge. If you're talking about the risk of injustice in a criminal context, it's the same. The magnitude of what's at stake is the same. And when in Fernandez, the case of Fernandez, can I just say it and then take you to it? When Lord Justice Diplock, as he then was, says we're going to apply the real risk test for the future because common sense and humanity dictates that, because of the magnitude of what's at stake, think of what it involves if you get it wrong. We say that exactly the same applies here. It's not just some common or garden violation of Article 6, some domestic violation. It's a flagrant denial of justice, a complete abnegation of the right to a fair trial without a remedy. And so, my lord, that's our first point, that if you look at the two tests, the magnitude of what's at stake and the difficulties of proof, they apply equally in the Hoffman situation and in this case. Secondly, in a case such as this, where the allegation is of alleged corruption and bias, given the special problems of proving such undisclosed matters, a requested person is not required to demonstrate more than a real risk. And, my lords, we deal with that in Part 7, dealing with bias. And, my lords, I think that my Lord Stevens put to my known friend the question about the Porter and McGill test. You first ascertain the relevant circumstances, and then you say, in the light of that, what's the position? The relevant circumstances that you ascertain, and we've dealt with this at Part 7. What was it? Part 7. 7.6 at page 148. So what are the relevant circumstances here? That Lord Gough said you must inquire into from the available evidence. That the judge is a suspect in an in personam investigation for influence peddling. That at least 3 persons, Tejana, Dumitrescu and Opus, had made unanswered allegations, and indeed Dobrin and Ogunguriano too, that he had a corrupt and improper relationship, and that he had both solicited and accepted bribes. These relevance alone would justify finding there's a real possibility, and then there's no rebuttal by the court or the state. They would not have discharged the burden of showing that there would be no flagrant denial of justice. Now, my lords, if you go to Porter and McGill just for one moment and look at tab 11 of Porter and McGill, where it sets out what is the mandatory requirement for a valid trial. Page 2069 at paragraph 88. It says there is a close relationship between the concept of independence and that of impartiality. In Finlay and the United Kingdom, the European Court said, and then can I just go on to, as to the question of impartiality, there are two aspects to this. First, the tribunal must be subjectively free from personal prejudice or bias. Secondly, it must also be impartial from an objective viewpoint. That is, it must offer sufficient guarantees to exclude any legitimate doubt in this respect. And so, my Lord, those are mandatory requirements. It would be very odd if one could say, well, I know that that's a mandatory requirement before you even get off the ground of a trial. And I know that the judge may well have been corrupt and partial. But that's not enough, because I can't prove it on the balance of probabilities. And in a criminal context, I would very respectfully suggest that the court would never adopt that approach. Supposing that you get a jury, and we've got a case which could exhibit this, a jury where there's a suggestion that the juror had been offered a bribe or taken a bribe or played with a Ouija board, which was one of the famous cases. Would the Court of Appeal say, they may well have fooled around with a Ouija board, but we can't prove it on the balance of probabilities, and they've refused to answer any questions about it, so the verdict stands. It's just...
Mr. Fitzgerald, my understanding of the jury cases is that it is the Porter and McGill test, and you have to establish the circumstances, all the circumstances, on the balance of probabilities. So I don't see any departure from it at all.
Well, my Lord, there is we can produce it overnight. There is a case where Lord Mant said it's possible, and that's enough for the jury to set it aside. So, my Lord, well, your Lordship has our alternative submissions are: one, if they may well have been biased, that's enough. But two, that may well have been plus silence converts into they were sufficiently for proof.
But should we be applying the Porter and McGill test at all? I asked whether or not there is an autonomous concept that is applicable in this area. And what do you say about that?
You mean in terms of the European Convention?
Yes, because the obligation of a court not to return somebody to under a European arrest warrant arises because there would be a breach of Article 6 or Article 5, and therefore you have to determine whether or not there's been a breach in accordance with the concepts under those articles, not in accordance with the concepts under domestic law.
Well, it's true, but Finlay is the European Court saying it must satisfy those three tests. It would appear that there's a mandatory test which, if not satisfied, would lead to invalidation. My Lord, so that would be my respectful answer, that unless you can say, well, they were, if you raise a cogent case that there's legitimate reason to fear that they weren't, and it's not answered, then you cannot say that the conviction satisfied the test, the mandatory test under Finlay. So, my Lord, I think that is, to that extent, it's an autonomous concept under Finlay in the UK. My Lord, that's the point that we respectfully make on bias. But your Lordships will see that we've made the point in Part 7 that there are a number of reasons why this should be the approach. Firstly, because of the great importance of the requirement of impartiality, which we've set out at 7.2, referring to the case of LM, which your Lordships will find at 2844, where they stress the cardinal importance of impartiality. So that's at paragraph 48 at page 2844, LM stressing part of the importance of impartiality. Judicial independence forms part of the essence of the fundamental right to a fair trial. And then one sees at paragraph 58, the high level of trust between member states on which the European risk is based is thus founded on the premise that the criminal courts of enforcement meet the requirements of effective judicial protection, which include independence and impartiality. So, my Lord, I suppose that's the point, is that it's premised on we will extradite, provided your judges are impartial. And where there's reason to doubt that the judge was impartial, we say that duty of reciprocity is called into question. And then just again, the case of Al Hassan, tab 12 of the bundle, stressing the crucial importance because it would render it a nullity. And that's drawing on both domestic and European case law, saying that without being independent and impartial, the whole decision is a nullity. My Lord, that's Al Hassan, paragraph 43 at page 2106. At page 2106, yes. And your lordships will see that that's where Lord Brown stresses that the cardinal importance of independence and impartiality. The decision itself was necessarily as tainted by and cannot be permitted to stand if, as a matter of principle and authority, if it's impugned for want of independence and impartiality. So, there's that point, and we do also point out that there are a number of cases which are collected in Netezirayo where there has been a finding of flagrant denial of justice because of the lack of independence of the executive. We've set them out at 7.2, and you can find them in the Netezirayo case at page 3025, paragraph 88. So, and then the next point we make is that bias and partiality are particularly difficult to prove. And then the next point is that there's a duty on the part of a judge to disclose the true position where reasonable inquiry is made. And in the absence of such disclosure, it is not reasonable or fair to impose a greater burden on the requested person than to establish credible evidence that the judge may well have been corrupt or biased. And that's the decision in Remley, my lords, which we have at page 4759 at paragraph 48, which says where it's disputed on a ground that does not immediately appear to be devoid of merit, courts are under an obligation to check whether they can be considered to be impartial. And again, Cubber Belgium, which is at the relevant paragraph, is 27 in Cubber Belgium at 4155. Any judge in respect of whom there is a legitimate reason to fear a lack of impartiality must withdraw. So this norm clearly imposes a duty on any judge, and we would say, therefore, on the requesting authorities in this case, when it's raised at the post-trial stage, to investigate alleged bias and ensure either recusal or in this case, subsequent invalidation on appeal.
I do apologise. Whereabouts on page 4155?
Okay, my lord. So 4155. It's paragraph 27.
Yes.
In Cubber. Does your lordship have it then?
Yeah.
So if you look at what they're saying is wherever there's legitimate reason to fear, then they must withdraw. That's a principle of European Convention law. And we say that we've at least established that there were legitimate reasons to fear that Judge Tudoran was not impartial, and then there's a burden shifting onto the authorities to investigate and check whether, in fact, he was impartial. So, my lords, when one talks about ascertaining the relevant circumstances, it includes a duty to investigate where there are legitimate reasons to fear a lack of impartiality, and it includes all the relevant factors that we've drawn attention to about the unanswered allegations and the inquiries in this case. And we would say that the relevant circumstances need not necessarily be proved on the balance of probabilities. It depends on what it is reasonable to expect in the circumstances. Now, my lords, we then come on to, can I just, if I can give the court the reference, it's a case called Brown. We'll get it overnight if 2001 EWCA Crim 2828, which makes findings about
Page again?
It's page it's 2828, Crim 2828. That's the jury point. I told you, my lord, we will get it overnight.
So this is 2828 is not.
Oh no, it's not in the. No, it's not in our.
This is something you're going to produce
yes,
tomorrow.
My lord, we're going to get that. Yes. So, my lord, that's the point, that here, where the issue is bias, the determination of the relevant circumstances need not necessarily be on the balance of probabilities, particularly in a criminal context. And particularly where the allegations are of the magnitude here. The next point we make is that, as my Lord Hodge put to me, that this is that given their failure to dispel the concerns that arose from the evidence, the prima facie case of a violation can justify the imposition of a burden on the requesting state to dispel any doubts. And your lordships will see that in relation to the risk of an Article 6 violation in a domestic case, Hoffman, tab 21, we've set it out. A flagrant denial requires a breach of principles of fair trial guaranteed by Article 6, which is so fundamental as to amount to a nullification or destruction of the very essence of the right. In assessing whether this test has been made, the court considers the same standard and burden of proof should apply as in Article 3 expulsion cases. Therefore, it is for the applicant to produce evidence capable of proving substantial grounds for believing if he's removed, he would be exposed to a real risk. Where such evidence is adduced for the government to dispel any doubt. Now, I accept that that's in the prospective situation, but it's our submission that where you've shown credible evidence that it happened in the past, a similar burden arises for the government to dispel any doubts. And at 8.3, we've referred to the case of Ananayev, which your lordships will find the relevant passage, paragraph 121 at 2278. According to its established case law, proof may follow from the coexistence of sufficiently strong, clear, and concordant inferences or of similar unrebutted presumptions of fact. Moreover, the level of persuasion necessary for reaching a particular conclusion and the distribution of burden of proof are intrinsically linked to the specificity of the facts, the nature of the allegation made, and the convention right at stake. Now, my learned friend says, oh, that's a license for, that approach is a license for, well, you can apply any test you want. But what we're saying in our respectful submission is that here, the proof did follow from the coexistence of the facts, and it was sufficiently proved on the facts of this case in the light of the silence of the requesting state. And my lords, we've set out Merabishvili in full. at 8.4, and really we rely on paragraphs 311, paragraphs 312, which is set out at page 149, and we rely on paragraph 313, the possibility for the court to draw inferences from the respondent government's conduct in the proceedings before it is especially pertinent in situations which the respondent alone has access to information capable of corroborating or refuting the applicant's allegations. And we do respectfully submit that the government, the prosecutor, who called Bicali and who threatened him with prosecution if he didn't give evidence, perfectly capable of asking him a straightforward question and getting an answer. And the same is true in relation to the judge. It wasn't, are you guilty of unexplained wealth, that was the crucial starting question, but do you know Bicali? That was the question, amongst others, posed by my learned friend, to which we got the ambivalent and unsatisfactory answer, we didn't know about it at the time. My lords, so you've got the Merabishvili further thing about the covert nature of the operation, and I know my Lord Hodge referred to the particular situations there may be where you go into prison, so you go into custody and then emerge with bruises, but this is a situation where we say that the court can also draw inferences from the silence. And it's not the case that this principle is restricted to cases under Articles 2 and 3. In the Bakker case, which did not include torture or detention, the Grand Chamber of the European Court applied the approach to an Article 3 that the burden of proof should shift to the government, where there's prima facie evidence in favour of the applicant's version of the events. Well, that's tab 63 at 4010. So
it was an Article 3 case, but the treatment fell short of torture. Is that your point?
Article 10. It was an Article 10 case. But it was an Article 10 case. Right. He was president of the Supreme Court, and he challenged the termination of his term of office. And he spoke out on the Constitution. The question was, could you draw an inference from all the circumstances that he was being, that the termination or non-renewal of his contract was because he'd spoken out? And your lordships will see at paragraph 143, page 4008, that you have.
Paragraph 123 at
paragraph 143, my lord.
43.
Page 4008.
Thank you.
So it's really halfway down. Proof may follow from the coexistence of sufficiently strong, clear and concordant inferences or of similar unrebutted presumptions of fact. It has been the court's practice to allow flexibility in this respect, taking into consideration the nature of the substantive right at stake and any evidentiary difficulties involved. In certain instances, only the respondent government have access to information capable of corroborating or refuting the applicant's allegations. Consequently, a rigorous application of the principle affirmante non negante incumbit probatio is impossible. Although these principles have been mainly applied in the context of Articles 2 and 3, there are examples in which they've been applied in respect of other convention rights. So in that case, Article 10, in this case, of course, Articles 6 and 5. And they look at the sequence of events, and they say, effectively, at paragraph 143, it can be unfair to put the burden on the applicant. And you can see at paragraph 148 the application of that principle, page 4010, in the court's view, having regard to the sequence of events in their entirety, rather than the separate and distinct incidents, there is prima facie evidence of a causal link between the applicant's exercise of his freedom of expression and the termination of his mandate. This is corroborated by the numerous documents. These include not only articles published in both Hungarian and foreign press, but also texts adopted by the Council of Europe. The Court is of the view that once there is prima facie evidence in favour of the applicant's version of the events, existence of a causal link, the burden of proof should shift to the government, where the reasons lie within the knowledge of the government, the reasons.
Which paragraph are you reading from?
So, my Lord, page 149, para 149.
Thank you very much.
The court is of the view that once there's prima facie evidence in favour of the applicant's version of the events and the existence of a causal link, the burden of proof should shift to the government, particularly important in the case at hand, since the reasons behind the termination of the applicant's mandate lie within the knowledge of the government and never established or reviewed by an independent court or body. So we can't have a hearing other than such as we had. My Lord, my own friend...
It is a bit odd that the Strasbourg court seems to want it both ways. On the one hand, they say there's no burden of proof, and now they talk about a shifting burden of proof. It's not entirely consistent.
No. Well, my Lord, I think as a principle of equitable treatment and common sense and justice, the notion, which permeates these cases, that where the requesting state, because the judge is a functionary of the state, and the witness is their witness who they adduced and remained a witness who they called and relied on to put someone in prison, they have got a duty where there's a prima facie case that witness and that judge.
Well, it would be more consistent with their stance to which we referred this morning if they were to say once there's a prima facie case and they have knowledge of the matter and don't respond, then inferences can be taken against them.
Yes.
It's really the same.
Yes, yes.
It's the same point dressed up in other language.
Yeah, well, my Lord, yes. I suppose once we've dealt with once we've established, which we say 362 does establish, that there was reasonable grounds to suspect that it may well be true, then the court found an unsatisfactory lack of investigation and an unsatisfactory inadequate response. And we say you put those two together and you have a sufficient finding on the balance of probabilities that it is the case. Or using the more general expression of the Hoffman case, Mr. Popoviciu has discharged the burden which it's fair to impose on him. And so, my Lord, if we look, and then, my Lord, at 8.7, we've made the point, drawing on Coombs and Preston Petrodel, that's tab 49 at 3582, but I did show it to the court, that in our legal system, generally, the silence of one party in the face of the other party's evidence may convert that evidence into proof in relation to matters which are or likely to be within the knowledge of the silent party. Now, my Lord, I accept it's not an exact analysis, it's not the actual individual, but the state has the power to obtain an answer from the actual individuals who the state relied on to try the case and to be their key witness in relation to the case. And so, my Lord, when we look at the High Court finding, and I know the court has the point, at 162 they say it may well be true, but 163, having made that finding on the basis of Dojano, Dumitrescu and Opris, they say they failed to address it. We say if you put those two findings together, actually, it legitimately justifies a finding on the balance of probabilities. And if we look at what the High Court did, they say, accept the oral evidence of Dojano and the written statements of Dumitrescu and Opris satisfy the Veniavesi criteria, should be admitted as fresh evidence. On the basis of that fresh evidence, I'm satisfied there are now substantial grounds for believing there's a real risk that the appellant was convicted by a judge who could not be impartial because of his undisclosed relationship. Well, that's the evidence of those three witnesses. As the court knows, there were actually other witnesses, Dobrin and Ungariano, and Dobrin actually said in his evidence, I'm too frightened to give evidence, to have my name disclosed. And he says that in his statement. So there is evidence of fear there. I can give you that reference, my lords. Dobrin is referred to in our summary. Yes, it's at page 5772. He says, I'm fearful of Judge Tudoran. And on the question of fear, Dumitrescu talked about Judge Tudoran being an intimidating person at 5755. And Dojana talked about his fear. He said, I didn't have the guts to raise the case until I had the backing of Cesar Panet, and that's at page 5680. So there was lots of evidence of fear on the part of the witnesses. And we say that the court, and this we set out at 8.9 at page 151, having said the appellant has plainly failed to put forward any evidence or information which dispels these concerns, should have gone on to consider how that failure to respond ought to be factored into its assessment of the overall strength of the evidence. That's at 8.10, my lord. It's clear, however, from the approach of the European Court, the state's failure to dispel any doubts is sufficient to make out a finding of a prospective real risk precluding extradition. But we'd also say it'd be sufficient to justify a finding on the balance of probabilities. My lords, we've made the further point, and this is at 8.11 to 8.12, and I appreciate the court's now had some time to look at it. The response, neither the case prosecutor nor the hearing prosecutor was aware at the time of the investigation of the existence of a friendly relationship, certainly is open to the interpretation, a reasonable interpretation, saying, well, it exists, but we didn't know about it at the time of the trial. And we say that it further underlines the reasonableness of drawing an adverse inference. And, my lord, we do make the point that some of the criticisms of Dojana's evidence were unjustified. My lord, I can summarise those by reference to the factual position, if your lordships would permit me to. That may require going through the facts, which your lordships might want me to do tomorrow. So shall I just finish the broad outline of our case and then go back to the facts? My lord, if you go on to part 9, we say that and this is at page 153, we say that if the court finds the High Court applied the wrong standard of proof to the question of whether the respondent was convicted after a flagrantly unfair trial, the respondent submits as follows. 1, the respondent has discharged the burden placed on him to demonstrate there are substantial grounds to believe that there's a real risk that his conviction was issued by a corrupt and biased judge. The High Court's finding that Judge Tudoran may well have been corrupt was amply justified by the evidence of Dojana, along with the powerful evidence of Opris and Dumitrescu. My lords, I delete the reference. What I can say in relation to Roman 2 is there has been nothing from Judge Tudoran or Becali to dispel those doubts. And the appellant has failed at the time to respond to the specific questions posed by the CPS, and has not taken the opportunity to put in any denial from either Becali or Judge Tudoran. And they didn't, at any stage during the proceedings, deny that existed an improper relationship. Now, the High Court didn't expressly consider how the failure to respond ought to be factored in. It reached the conclusion there were substantial grounds to believe there was a real risk that the conviction was based on a flagrantly unfair trial, but it then went on to introduce the silence of the Romanian prosecution as a separate issue, and they didn't consider how that silence must necessarily convert the evidence into proof. So to that extent, we, as your lordships know, we say they could have gone further and would have been justified in doing so. My lord, those are the points on the main issues. I would like to go back through some of the authorities tomorrow to show that if one examines the authorities about the past conviction cases, many of them are actually concerned with the question of the height of the test for a flagrant denial of justice. And none of them really, with perhaps the exception of Lison, go into any analysis of why the test should be on the balance of probabilities rather than real risk. My Lord, we've set that out. But what happens is, time and time again, you get Suring saying, if he risks having an unfair trial or has had an unfair trial, then that would give rise to a reason to refuse to extradite. But it just uses the temporal expression or has had an unfair trial without analysing the test that you apply in determining whether they have had an unfair trial. The only case in the European Court which goes into that issue in detail is Hoffman. And your lordships have seen that applied the test of what, in relation to a flagrant denial of justice, is the burden that it's fair to impose on the appellant. And so, my Lord, that's the exercise that we conduct at part 5 of the analysis, and at part 6, where we deal with the question of what the authorities actually show. Well, I think I can do that quite shortly tomorrow, but just to summarise, you'll see, looking at page 140, for example, Suring has suffered, 6.3, has suffered or risks suffering. That citation sheds no light on the burden and standard of proof. It merely seeks to distinguish between a flagrant denial of justice in the past, denoted by the words has suffered, and a flagrant denial of justice in the future, denoted by the words risk suffering. And that's the same in a series of subsequent cases, which my learned friend relied on. And one sees that in the case of Drozd, it's the test at 110 is the contracting states are obliged to refuse their cooperation if it emerges that the conviction is the result of a flagrant denial of justice. It doesn't deal with the standard of proof. Nowhere in Drozd does the European Court deal with the issue that faces this court. And really, if you look at Drozd, it's all about whether what went wrong in that case was sufficiently serious to amount to a flagrant denial of justice. The majority thought that it wasn't, a strong minority thought that it was, but that's the focus on, is it flagrant, not is it proven on the balance of probabilities. So Drozd is about the high test that has to be satisfied to constitute a flagrant denial of justice, and not about the standard of proof. My lords, Stoichkov and Bulgaria, which is at tab 80, the passage you've got at 6.8 is also at page 4968. The question was whether the requirements of Article 6 to ensure the right of the accused to be present during the proceedings against him is so basic as to render proceedings conducted in absentia and whose reopening has been refused a flagrant denial of justice. So it's about, again, the extent of the injustice, the standard of the injustice, to satisfy the high threshold of flagrant denial of justice. And then Hoffman and the UK, I've taken the court to, but that is the only case which goes into detail about what should the test be in this very particular type of situation where you're trying to establish a flagrant denial of justice. And they analyse it in great detail in the passage from paragraphs 273 to 282 that I've taken the court to. And So in the only case where they've found a flagrant denial of justice, they say that may well have been is enough. May well have been obtained by torture is enough. And that may be an indication that that's the workable basis on which you can operate. Wilcox, at 6.10, tab 81, quite simply, that was not a case about the application of the burden and standard. The matter in dispute was whether a conviction based on an irrebuttable presumption constituted a flagrant denial.
Which page?
It's Wilcox at 4. Is it paragraphs 95 to 98 of Wilcox at tab 81? Can I just? I'll just find it. Can you just give me the page? Wilcox. Yes, but the actual page where paragraphs 95 to 98. So it's paragraphs 95 to 98.
494, right?
Is it page 4994, my lord?
Thank you very much indeed.
So that again, it's not a case about the burden and standard. It's a case about how bad does it have to be before it's a flagrant denial of justice. So we say that the standard to the past event of torture manifesting a real risk that ought to apply to past events, in the only case where it's actually looked at in detail, which is often, might well have been is enough. Now, it's quite true, if we turn to the domestic cases, that there are 2 domestic cases which look at it.
Whereabouts in Wilcox does it say might well have been is enough?
Well, my lord, no, my lord,
it's not.
I said no. My point was, in the only case in which they found, which is often, the point about Wilcox, Drost, and all those other cases is that they didn't find a violation, and they didn't find a violation because it wasn't sufficiently serious to constitute a flagrant denial of justice. That's the point I make. Would your lordship like me to take you in a second? So, if you look at all the other cases, Stoichkov, Drozd, etc., they are not about the test. They're about the quality of injustice that will satisfy the threshold of flagrancy. My lord, I'm just coming on to the domestic cases. Would this be an appropriate moment, or shall I carry on?
If you wish to, you will have till 12:10 tomorrow morning.
Okay, well, my lord.
Because the appellant finished early.
I'm very grateful, my lord. In that case, if I can break now, I'll deal with Lizon and Kaderli.
You're comfortable with that timescale?
Yes, so if at 10:30, so your lordship's saying that I have another hour and 40 minutes, yes.
You have an hour and 40 minutes.
My lord, I'm sure.
You seem to be making good progress.
I wanted to take you through some of the facts briefly at the final, because there is this issue of remittal, this issue of whether we would in any event satisfy the balance of probabilities test, my lord. I think
your case, as I understand it, on balance of probabilities is if you combine what the Court of Appeal has, the High Court has found, with the lack of proper denial, that takes you over.
Yes.
That takes you up to that standard.
And my lord, there are 2 other. Can I just, before I break, just give you 2 other factors? There's also the fact that he was under investigation and appeared to be evading the investigators in relation to 1603. That's the influence peddling. And my lord, and I will take you to the relevant passages, his conduct in relation to the civil proceedings was bizarre and unlawful, and that's set out again in the judges, in the findings of Lord Justice Holroyd, but they didn't appear to factor those in. But I can just give you, your lordships, in the High Court, they analysed his conduct of the civil proceedings at paragraphs 25 and then again at paragraph 33, and his bizarre and unlawful behaviour in relation to the civil proceedings is set out fully at pages 508 to 509.
Could you just give those references again, please?
I'm so sorry. So, in the High Court judgment, it's at paragraphs 25 and 33, and there is a full analysis of the illegality of the judge's behaviour in the civil proceedings at pages 508 to 509 of the skeleton before the court, and that sets out a chronology which is adopted by the High Court.
Where does the High Court adopt that?
At paragraphs 25 and 33, my lord.
25 to 30.
25 and they deal with it first at 25 and then again at 33. I mean, my lord, in essence, he was ordered not to give judgment in the civil case, and despite being ordered not to do so, he got his son to deliver a judgment after the court had said that he couldn't do it, and as a result it was struck down as a complete nullity, and that suggests acting irrationally and unfairly towards Mr. Popoviciu in closely related proceedings.
And what did the High Court in Romania make of that?
Oh yes, the High Court in Romania has quashed the civil proceedings,
yes,
the judgment in the civil proceedings, and ordered a retrial, which I think is going on now, of the civil proceedings.
Right.
Yes, I see some nods. What it effectively means is that this judge was acting on a charitable view bizarrely, and on an uncharitable view maliciously and unlawfully in relation to the civil proceedings. He did something he was ordered not to do, to the prejudice of Mr. Popoviciu, and as a result his decision was annulled. So it's a whole, if you look at it, that language of concordant circumstances, it's 5 witnesses.
But just so I can fully understand it, was that a ground of appeal against conviction in front of the High Court in Romania?
No, because it hadn't happened yet.
Right. Okay.
It happened afterwards.
Was it a ground of appeal against conviction that the judge ought not to have separated out?
My lord, yes.
Was.
Yes, that
was rejected.
That was rejected, my lord. But what he did after it was separated,
yeah,
was ruled to be unlawful. And so if one's saying, well, is there any evidence that this judge, who there's reason to suspect of bias and corruption, behaved badly towards the defendant, there is in the civil proceedings, and I can take your lordships to some passages in the judgment, which your lordships have at tab 9. He just simply reproduces the prosecution case. It's littered with him assuming the language of the prosecutor. I referred, we hereby quote. He's page after page of it is him just adopting everything the prosecution said.
Well, I think we can come to that.
My lord, yes, sorry. Just giving you a foretaste, my lord.
When I adjourn.
Thank you very much.